I think the question that will formulate as this works its way through the courts, which it will work its way through the courts. Already groups have announced that they're going to be challenging this rule. I think the question will be focused solely on not the sweep of the Clean Air Act more generally, but whether the Clean Air Act covers greenhouse gases and it's part of that larger sweep. And I just think that's where we're headed.
This is Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan. Please subscribe or follow this feed on your favorite podcast app. That way, you'll have access to all our new episodes as soon as they're available. And this is an episode that's especially hot off the press. I'm really lucky today to be talking with my colleague, Debbie Sivas. Debbie is the Luke W. Cole Professor of Environmental Law here at the law school. She's also a professor at the Dorr School of Sustainability. She's the director of our Environmental and Natural Resources Law and Policy program. She's the co-director of the Environmental Law Clinic, and she's a senior fellow at the Stanford Woods Institute for the Environment. So thanks so much for joining us today, Debbie.
Thanks. I'm happy to be here.
Well, I don't think you're actually happy to be here, in a sense, because yesterday, the Environmental Protection Agency announced a rescission of the greenhouse gas endangerment finding and motor vehicle greenhouse gas emission standards under the Clean Air Act. This is a huge deal. Indeed, the administration itself is calling it a huge deal. They're calling it the largest single deregulatory move in the history of the United States and perhaps in the history of the world. So I think maybe the place to start is to start with, under the Clean Air Act, what is an endangerment finding and what happened in 2009?
Sure. And I will say that might be the one thing I agree with, that it is a huge rollback in regulation. So yeah, let's go back to 2009. So the Clean Air Act, which was passed in 1970, so a long time ago, and really originally was focused on traditional local air pollutants. So it has a provision related to air pollution emissions from motor vehicles that says that the EPA must take a look at whether vehicular air emissions, quote, cause or contribute to air pollution which may reasonably be anticipated to endanger public health and welfare. So that's where the endangerment comes from. And in 2009, after a lot of back and forth in the courts, the incoming new Obama administration made a finding, the endangerment finding, that determined that greenhouse gas emissions, and that's carbon dioxide, methane, and a few other pollutants, were in fact endangering public health and welfare. So that's the original finding back in 2009.
Right. So we had this finding that certain gases that, among other things, are emitted by cars. And I think in the United States, if I understand it correctly, the major source of greenhouse gases is automobiles.
The transportation sector.
Right. And obviously planes and trains, buses, right, and the whole business. And the idea was that this endangerment finding would give the government a reason to regulate greenhouse gases. And among other things, it started to regulate how much car emissions, right?
That's correct. So once the endangerment finding was made, then EPA went forward to look at. So of course, we've had fuel economy standards for many years, dating back decades, but went forward to really look at accelerating the mileage standard, that is higher miles per gallon, as a result of the endangerment finding. And that's led to, in the vehicle sector, that has led to not only internal combustion engines that are more efficient, but also the proliferation of alternative, particularly electric vehicles, and then hybrids, which help to get the fleet-wide mileage standards up.
Yeah, so originally when the Clean Air Act was passed and they were thinking about the health risks from cars, the one they were mostly thinking about was people just actually inhaling the particulates, right?
Yeah, that's correct. Particulate matter, ozone formation, things that led to ozone formation. So yes.
Yeah, so it was basically, there was this kind of direct relationship between the car spews out the stuff, you breathe in the stuff, bad stuff happens.
Yeah.
But we now know that greenhouse gases have other effects on people's health and welfare. And maybe just kind of give our listeners a sense of the range of those other effects.
Yeah, so they're all around us, right? But probably the most obvious ones are so greenhouse gases. I think it's other than maybe the current administration, it is pretty much undisputed that those gases are leading to climate change in ways that are affecting all of us, and the local climate is a manifestation of that. So we're seeing more hurricanes, more wildfires, more intense wildfires, sea level rise. And so things that are all around us and obviously affect the public health and welfare in ways that are different than breathing in the individual particles. Yeah.
Right. So we now have an administration that I think is, if I understood from reading the executive summary of the rescission and the like, they seem to have kind of 3 or 4 different arrows in their quiver. One seems to be just a doubt about whether climate change is real.
Yes, and so there was a proposed rule that was put out in last September, right, that actually had even more quivers. They've narrowed it down in this rule. Maybe their lawyers thought about what would be actually the most defensible in court. And so in the original proposed rule, the administration really took on climate science quite directly, and there was a lot of blowback in that because there were questions about the science that they were relying on. There's pretty much, except at the very fringes, there's pretty much consensus that climate change is happening. So they're kind of making some gestures in this rule, but not really relying on attacking the climate science directly. This rule is more focused on some of their legal arguments.
Right, and their legal arguments seem to start from the idea that because in 1969, the kind of harm that Congress was thinking about is people breathing in little dirty bits of what was coming out of a tailpipe, that Congress somehow couldn't have been thinking about other forms of danger to people's health. Because I think, I saw one estimate that thousands and thousands of people are going to die from smoke from wildfires caused by the increase in greenhouse gases.
Right. And
so those people actually are, in a way, breathing in a bunch of dirty stuff that's coming to them. It's just that it's taking 2 or 3 more steps along the way to get from the tailpipe of the car to the stuff they breathe in.
Yeah, that's absolutely right. Right. And there's a growing science called attribution science, which links the increase in intensity and frequency of things like wildfire. It links it directly to climate change. So you've got that 2 or 3 step process, but people are still being impacted, and probably more so. I mean, I work some in the wildfire space, probably more so than all of the smog that we had in LA in the 70s put together. Right. It's coming.
Yeah. And what interests me about that is that the science tells us that it's still people breathing in stuff, but the administration wants to argue in an almost kind of Paul's Graphian way that unless you're breathing it in directly from the tailpipe of the car, it wasn't within Congress's contemplation when they passed something called the Clean Air Act, that they only cared about that first kind of dirty air and not about the dirty air that comes from all of this other stuff.
Yeah, I think that's absolutely what they're trying to do. And of course, they're trying to do it in a slightly more subtle way by going back to some of the recent Supreme Court precedent and making a weaving an argument that the court should go back and revisit whether greenhouse gases at all are even covered by the statute.
Yeah. Now, when we talk about the cases the Supreme Court's decided recently, I guess you're sort of alluding to at least 2 of those sets of cases, the major questions doctrine cases, and then the Loper-Bright decision about that overturned Chevron. So maybe you could explain a little bit for our listeners about the major questions doctrine, which has become a general doctrine, but it really almost all of it has come from environmental law cases.
Yeah, no, that's right. So just to step back, right, before the endangerment finding happened in 2009, there was a fight in the Supreme Court about whether this very question we've been talking about, whether greenhouse gases, whether Congress covered those in the Clean Air Act. And there was the Supreme Court case, Massachusetts versus EPA, that said, yes, those greenhouse gas pollutants could be covered, and that the EPA needed to look at those in terms of the endangerment finding. And then EPA made the endangerment finding that related specifically to the vehicle emissions, as we've been talking about. But once that was done, then EPA, based on that finding, moved on to stationary sources. So those are things like power plants, industrial facilities, and started looking at regulating those. And one of the things it did was something called the Clean Power Plan, which was trying to ratchet down particularly carbon dioxide emissions from power plants. And that rule was promulgated and then led ultimately to a case that went up to the Supreme Court in the West Virginia versus EPA. And that's the case where EPA said, really articulated the major questions doctrine, where it said if Congress had intended to regulate such a large swath of the economy, it needed to say that very clearly. And the Clean Air Act does not say very clearly that that's what it intended to do. Because again, it was 1970 at the time.
Yeah. So the argument here, I take it, that the administration is making is regulating cars in the way that the EPA sought to regulate cars after the endangerment finding was the kind of thing you would have expected to hear more out of from Congress before the agency should move into this new area.
Yeah, and not just cars, but greenhouse gases, really.
Right.
Like before EPA should really do any of this greenhouse gas regulation, Congress needs to be much more clear that that's what it intended EPA to do under the Clean Air Act.
But it seems to me that the Clean Air Act was such a major piece of legislation that it really was Congress saying, we think the federal government should get into the business of making sure we have clean air. And it was going to leave to an administrative agency with some expertise and some science and a process for thinking these things through, how to instantiate that commitment to clean air. But the commitment would seem to me to be almost in the statute's title.
Well, right. So we need you to be arguing the case that works its way to the Supreme Court. But yes, so right, the Clean Air itself was very sweeping new legislation. We had not done anything like that, little bits and pieces, but not anything that sweeping. And really, I think the question that will formulate as this works its way through the courts, which it will work its way through the courts already. There's been announced, groups have announced that they're going to be challenging this rule. I think the question will be focused solely on not the sweep of the Clean Air Act more generally, but whether the Clean Air Act covers greenhouse gases and it's part of that larger sweep. And I just think that's where we're headed.
So before we get to where we're headed, just one other piece of this, which is the Supreme Court's decision in Loper-Bright.
Yep.
In 1984, the Supreme Court decided another environmental law case that involved Chevron against the NRDC. And in that case, the Supreme Court said when a statute is ambiguous, courts should defer to the agency's interpretation of what its statutes mean, as long as that interpretation is reasonable. That is, the court wasn't supposed to say, well, what do we think the statute means? They were supposed to say, well, what does the agency think the statute means? And is that a reasonable interpretation of these words that aren't necessarily entirely determinative or clear? In Loper-Bright, the Supreme Court came back and said, we don't think that that's an appropriate thing to do. That is, we, the courts, are experts at interpreting what the words in a statute mean. And so we, rather than the agency, should determine what those words mean. Some of what, again, if I was reading the EPA's announcements and the like, some of what they seem to be doing here, though, is actually doing their own reinterpretation of the statute and saying, well, we're reinterpreting the statute and now that's what we think the statute means. But at the end of the day, doesn't Loper-Bright mean that the courts are going to decide this issue?
Yeah, well, that's right. The Loper-Bright, that is the way that you could think about Loper-Bright as applying, right? Because remember that the court said there's one best interpretation, and that's for the courts to make ultimately. And I think what they're going to argue, what EPA is going to argue in this case, is that there is one right interpretation. It was the interpretation that EPA took in 2008 or 2006 to 2008 under President Bush. And at that time, the EPA said, we don't think the statute covers greenhouse gas emissions, and that's how we're interpreting the statute, right? And so now, of course, the Supreme Court in the Massachusetts versus EPA case said no, it read the statute more broadly to cover greenhouse gas emissions. But so they're going to use the Loper-Bright case to say, well, there is only one best interpretation, and court, we think you should rethink what you said in Massachusetts versus EPA. I mean, they don't say that completely outright, but that's clearly where their decision is headed, trying to work that question back up to the Supreme Court. Of course, we have a very different court than we did 20 years ago, and I think that the sort of anti-climate policy folks believe they can get a reversal. And we've seen that the last couple of years. We've seen the Supreme Court really backtrack on some of this.
So if we start with, there are two kinds of attacks you might make against what the EPA just did yesterday. One is to say they didn't follow the process they should have followed to get there, which is a process in which they're supposed to take in lots of public comment. They're supposed to respond to it in a variety of ways. So one is a kind of procedural objection, and the other is a substantive objection, that the bottom line that they reached was just arbitrary and capricious and not supported by the evidence. How do you see those two things playing out in the attacks that, as you say, are already being prepared for and are about to be launched?
Yeah, formulated. Yeah. So the procedural ones, yes, there's definitely some procedural infirmities that I think can be litigated. And I would, so I'm not inside of any of the folks who are litigating this, but my guess is that that's one strand that they might try to play out, right? Because that could kind of delay this going forward in taking effect, and that they, in the strategy of someone challenging, you might start with the procedural issues and then ultimately get to the substantive issues. But my guess is that we're going to see some effort by the EPA to try to get this rocketed up through the courts to the Supreme Court, maybe on the shadow docket or something, and formulated in a way that tries to put that substantive issue front and center, so that you can get some ruling on that. Because otherwise, if you're toiling away on the procedural issues, that could drag out for the next 3 years, for instance, and we could have a change in administration which comes back and does another rule, which we've seen a lot of that in the last couple of administrations, the yo-yo back and forth. And I think they're really. Sorry.
Oh, go ahead. Sorry.
I was going to say, so I think the EPA is really hoping to get that substantive issue up front and get the current court to rule on that.
Yeah. And on the substantive issue, you were saying at the beginning of our conversation that there is a scientific consensus here that greenhouse gases cause these various effects on climate, which then causes various things like wildfires or like temperature changes and the like, that there really isn't much disagreement among actual scientists as opposed to, alchemists and necromancers and whoever else the administration is consulting with.
Right. And I think that's why the EPA's backed away a little bit from trying to rely on a factual argument around the science, although not completely. So two things. One is, of course, they dropped some notes that we're not giving up on that argument. We're just not going to rely on it as the primary basis to support this rule, and we're really going to rely on the legal arguments. The second piece of it is that a backup to the kind of West Virginia Loper-Bright, you should reconsider this rule and the prior ruling and uphold this rule. That the backup to that is that EPA is arguing that greenhouse gas emissions from the transportation sector, and again, this will affect all climate regulation, but right now it's just focused on the transportation sector because that's where the original endangerment finding was made. And what EPA is now saying is that greenhouse gas emissions from the transportation sector, even if you decarbonized the entire transportation sector and everything was electrified, that whole sector of the US economy, it would not have a material impact on what's happening with climate change. And therefore, it backs up their notion that Congress did not intend to regulate greenhouse gas emissions under the Clean Air Act. I would note that the word material impact is not anywhere in the Clean Air Act. The Clean Air Act says cause or contribute, right? But here EPA is saying it won't materially impact it because, of course, it's true in some larger sense. We're talking about the whole globe and all greenhouse gas emissions. So if you take one sector in one country, it may not have a material impact in the way the EPA is saying it.
So I want to now turn to that part of it that's about the regulation of essentially the auto industry is the one that they're putting the biggest kind of public face on,
Yep.
which is the rules that they're getting rid of there, the kind of fleet efficiency rules and the like. What happens when you get rid of those rules? What should we expect to start seeing?
I don't think they're going to entirely get rid of those rules. I think what this is driven at is to reduce the stringency of those rules. Like we've had those fuel economy standards in place, as I said, for decades. So, but they really ratcheted up starting in around 2017 or so, right? We've seen a pretty steep upward curve. And again, that was partly to get the public, consumers, and automakers to think about alternatives to the internal combustion engine. So I think what they're proposing is to really lower those standards, not to do away with them altogether, but it would, in my view, it'll certainly add to what's already happening in the current administration, which is to the kind of backlash to electrification of the transportation sector, and particularly electric vehicles that at the consumer level.
And this is at the same time that they're also doing that. There was the executive order telling the military to buy
Yes.
all of its power from coal-fired power plants.
Yep. Craziness. And of course, like the craziness around all this is, first of all, I don't think the military could buy enough coal-fired energy, but because it's just not that much left in the world. And why is that? In large part because it's not economically competitive today. And that's the same thing that's happening in the electrification of the transportation sector is electric vehicles and even hybrids are becoming much more competitive with traditional combustion engines. And in fact, more so, like we're not doing a great job yet in the United States, but nations like China are, they've really lowered the price incredibly for electric vehicles. So it doesn't even make sense from a kind of affordability perspective, but yet here's where we are.
Is this going to have any effect on the kind of California rules because California has its own set of rules that seem designed to really move us away from internal combustion cars over the next decade or so?
Yeah, so it could. So the California rules, which is another provision of the Clean Water Act, the Clean Air Act that allowed California to do more stringent regulations. So those and EPA has to allow that to happen through something called a waiver. So during the last administration, there was another waiver. There's been a whole series of waivers granted, and then it was rolled back through a Congressional Review Act of Congress. That is now under challenge in the courts, whether that rollback, which is supposed to be for rules, and this is a waiver, so there's a question of whether that even applies and what's the upshot of that. So that's all sort of is in the courts right now. But even assuming that the waiver is dead for now, right? Then California would not have federal authority to go forward. Then there's a question of, does the Clean Air Act otherwise preempt California standards? And like, if you roll back if you say greenhouse gases are not part of the Clean Air Act here, then the question is, well, then
if they're not part of the
Yes.
Clean Air Act, then Congress hasn't preempted the states
Right.
from dealing with them in the same way that the fact that, bubble gum is not part of the Clean Air Act means California could ban bubble gum tomorrow,
Right.
and the federal government would have no right to say anything about that.
That is the argument. I will say that the fight will probably be around. So this is all, it's all going to play out in the courts over the next couple of years, but the fight will probably be around because there's another agency that comes in here, and that's the National Highway Transportation Safety Administration, right? And they also regulate mileage efficiency, right? And but those regulations were really designed around efficiency of internal combustion engines and the miles per gallon. California's vehicle emission standards are really based on how much greenhouse gas you're emitting, so a different
Right.
logic. So how do those two interrelate? That'll be a question in a kind of preemption challenge.
And although the administration announced this is the biggest single deregulation in American history and the like, everything they do is the biggest.
Hmm.
Um, uh, this may turn out to be the biggest disaster in some ways. Is this a harbinger? Do you see them doing stuff like this across the board? Going back on the science and the regulation that has cleaned up our water and you're a water person, really, in a lot of ways. I mean, there are all of these waters in America today that are so much cleaner than they were when the Clean Water Act came in. Do we risk going back to sort of the Pittsburgh of the 1950s kind of feeling about the sky and Cuyahoga catching on fire? I mean,
Rivers.
is that where we're headed?
Well, I don't know. I think if our president had his way, we would be back in the 1950s, right? Which would not be a good thing from the environmental perspective. I think they're trying to roll back in many spaces, right? So not only vehicle standards, right? But if this endangerment finding rollback were to stick, that means all of the regulation of industrial facilities for greenhouse gas emissions, power plants, methane from oil and gas fields, and all of that would be also not available under the Clean Air Act. Most of it they've already started to roll back that. So this is trying to shore up that. But that's in the climate space. But more generally around water, local air pollution, endangered species, the National Environmental Policy Act, which is the act to disclose whether there are impacts from federally approved or federally funded projects. All of those are seeing simultaneous rollbacks in various ways, some of them probably more drastic than others. I will say the National Environmental Policy Act, so that's the basic charter that really started all of the environmental movement that says if you're doing a major federal project, you have to look at the environmental impacts and consider ways to mitigate or alternatives that will lessen those impacts. And the current administration has basically gutted that statute. So there's very little public process left. There's very little opportunity for the public to become engaged in those projects. So that's all gone away. We're seeing Clean Water Act. The agency is trying to roll back what the word waters of the United States means to be more constrained and narrow. So that could affect pollution. It also affects wetlands in a big way. So we already have lost about 90% of our wetlands, and this could pretty much torpedo the rest of them the way that they're proposing to roll it back. And then we've got the Endangered Species Act, where the administration is proposing to roll back the regulations that actually the Supreme Court blessed decades ago of what constitutes harm to species. So we could also see huge rollbacks there. Yeah, so it's coming in every sector.
And it's coming also with the kind of these are the things that I think of as the sort of regulations of dirty stuff, but they also seem to be rolling back on the provisions of clean stuff. So here, of course, I think of windmills as the paradigmatic example, but there's also the rollbacks on solar power, the rollbacks on electric vehicles and the like.
Yeah, absolutely. And of course, wind is the particular target of our current president. He doesn't like wind at all. And I would say that industry is really, when this administration first came in, it was not clear where all of this was going. So most of the tax incentives under the Inflation Reduction Act have gone away for renewable energy. But in addition, so that's one thing. Like, there's not, you're not going to get subsidies that will promote the growth of that. But some of these industries can begin to sort of stand on their own, and I would say solar is one. But now you have an administration, witness the rule around the military buying from coal facilities. There's now a very affirmative push to actually kill projects that would otherwise, even without subsidies, might go forward. So wind is one because wind is really on the cusp right now. And so some wind is quite feasible economically. The offshore wind, less so, and that's the stuff that the president really hates. But solar is more economically feasible. But now you have the administration trying to actively kill solar projects. And one of the things is that, as you know, in the West, I mean, a large swath of the West is federal public lands, and that's where a lot of the solar has been proposed. I mean, a lot of it is there, but also been proposed there. So unlike on a private property, the federal government has an ability to quash those projects, which it is now starting to systematically do.
Well, it's like the sun, the wind, the rain, the smoke. It's just,
Well, we love coal, so
it's
that's
kind of
great.
overwhelming. And
Yes.
I really appreciate your coming on the show, Debbie, on such short notice. So I want to thank Debbie Sivas, our guest today. This is Stanford Legal. If you're enjoying the show, please tell a friend and leave us a rating or review on your favorite podcast app. Your feedback improves the show, and it helps new listeners to discover us. I'm Pam Karlan. See you next time.